longer than he'd like to remember.
I was at Davis County for 27 years.
And
Now I'm a city guy though.
or city, excuse me, yes, Salt Lake City. So they keep them very busy. But Wolf has been our expert on what's been going on in the legislature and in the courts, and he's going to do our basic 101 with us this morning. Some of the basics of planning and zoning, to, as I say, to give you that background, make sure that everybody's comfortable with the acronyms and the lingo as we go through the rest of the couple of days. So, Will, I'll let you do any further introduction that you want to do for me this morning.
Well, first thing I'm going to do is break everything. Does that work? Can you hear? Okay. Well, as John mentioned, I'm Will Summercorn. I was at Davis County for 27 years. Now I'm a city guy. I went to the dark side. Been in Salt Lake City now for nearly 5 years. And how do I compare? People say, how do you compare working in Davis County to working in Salt Lake City? And I say, well, let me put it this way. Think of yourself as a gardener. And when I was working at Davis County, I would take care of my garden with a garden hose. It was great. You know, everything worked out pretty well. And now I'm in Salt Lake City, and I got a fire hose. And it's on all the time. It's certainly a crazy and interesting world to be in Salt Lake City. Then you saw the news this morning. You saw that we had a huge public controversy and public hearing going on over the alignment of the future streetcar out of Sugar House. And so, oh, somebody back, you must live in Sugar House.
Yep.
Which alignment do you like, Kathy?
Not down 11th East.
Not down 11th East.
Oh, no.
That's the line that the mayor likes.
The streetcar
so I gotta
to
say,
nowhere.
you're wrong, Kathy. All right. Well, let's talk a little bit about land use. I'm going to give you some of the basics of it. Several of you I know, I've known you for years and seen you before. How many of you here are staff? Just so I get a kind of sense. Oh, most of you. Well, shoot. I can go home now. You guys know this stuff. How many of you are on planning commission? Planning commissions. Okay, fair number of you. Anybody on an elected official? One. You better watch out. You're in trouble. How many of you are brand new planning commission? Okay, one. So some of you are kind of familiar with this. Well, so I'm going to treat this a little bit like a refresher course. To kind of get you back familiar with some of the basics of how land use works in the state of Utah and what some of the rules are. As Johnny said, kind of as a basis for what you're going to do. Let's see, I'm going to turn this around so I can get this a little bit easier. Hopefully it'll not crash like some good things do. Okay. There we go. Is this your idea of land use in Utah? I got to update this slide because there's a lot of younger people when I use this and they go, who is that? Is that some guy? You know, I don't know where he's from. Looks like he's was in a band or something. No, that is Joseph Stalin, for those of you who don't know. When I first started out in planning, land use control and planning was called communistic. And it still is by some people who are generally much older. Nowadays, I got to replace this with a slide that shows the United Nations, because it's a United Nations conspiracy. And for those of you who think that, my apologies, but it ain't. Or is it maybe this? Is this your idea of land use in Utah? You know, who's got the bigger and the faster gun? Or is it maybe something like this? I don't know if you can see that very well, but you know, the one guy painting his house is getting all the way. So what is it? What is land use to you? What is planning? Well, basically, what planning is and land use is, it's the citizens' vision of their community. It's expressed as a series of goals and objectives, which generally put life into a plan, the general plan or the master plan of the community. And then you implement that plan through various ordinances and budgeting and other things that you do, which then have the force of law. And so that's kind of the basic outline for it. We'll go through this in a little bit more and give you some ideas. The general stuff, if you want to look this up and you're really having trouble sleeping tonight, you can open the state code and read section for cities, it's 10.9a. I apologize. I should put the other one up here. For counties, it's 10.27a. Okay, this is the counties, but they're I'm sorry, 17. That's right. 10.17a.
1727.
Thank you. We'll get it right sooner or later. See, I've been away from the counties for so long, I can't even remember what the correct number. This is what's called LUDMA, or the Land Use Development and Management Act. And it was developed in its current form and adopted in the early 90s. But it was, the basis of it, it really comes from a lot further back than that. Planning kind of got its start in the early 1900s. And the first parts of it kind of came about because of the extremely bad conditions that existed in the New York tenements. And so the New York City government at that time determined that they needed to do something to kind of regulate a little bit how these tenements were built and how they were operated, make them safer and healthier places. And that was kind of like the first zoning. And that kind of developed over the years until in about 1924, the United States Department of Commerce put out basically a model code or model or section of state code that should be adopted that would govern how planning and zoning works. And most states in the country adopted that standard code that was developed. Utah, the state legislature adopted it in 1925 for cities, only for cities. It did not apply to counties when it was first adopted. Salt Lake City was the first city to adopt zoning in the state. That was in 1926. In 1945, the legislature finally also put this in the code for counties. Then over the years, there were a lot of amendments to it and a lot of things happened with it in court cases and everything else. So when I actually started in planning in the early 80s, and I kind of got interested, where does the basis for all this come from? And looked into it, and a number of us began to realize that these sections of the code were really getting cluttered up and hard to understand. So in the early 90s, this was all revised, and the LUDMA section of the code was adopted, which we did through the legislature in early 1992. I've been working with the legislature since that time. So it kind of feels like ancient history. And tomorrow we're going to give you a legislative update because I still go up to the legislature. This is my evidence of brain damage over the years, as I keep going to the legislature every year. And because some kinds of provisions regarding land use always come up every session, every year in the state legislature. And so tomorrow we'll give you an update on what the legislature did to us this year and what you need to know. Major revision, as you notice there in 2005, Senate Bill 60. So that just is where all this resides. Okay, I put this, because I'm a city guy now, a lot of this stuff refers to cities, but just kind of substitute county in there because it applies as well. And if it doesn't, I'll tell you, but generally it does. So, the local authority to plan and regulate resides with the governing body. In the case of cities, with the city council. In the case of counties, either with the county commission or the county council. They are the ones who are authorized to adopt plans and land use regulations and enforce them. The interesting thing is, before they can do any of that, they are required by state code to have a recommendation from the planning commission. Okay? They cannot adopt. This is an interesting thing, and people ask me this all the time, because they say, hey, our county council or our city council, they're going to do this. They're going to rezone this property, or they're going to change this part of the code. They're just doing it on their own. And I say to them, did they get a recommendation from the planning commission? And they say, no, they didn't ask anybody. They cannot do that under state code. It will invalidate the law. So as Johnny says, you want to be sure you're following the law. They have to have a recommendation from the planning commission. So those of you on planning commissions now, you do have a little bit of authority here. You have a role to play. You don't necessarily adopt them, but you have to provide a recommendation to the governing body on any plan, any zoning, any land use regulation, which is zoning ordinances, subdivision ordinances, and some of the other things that go along with that. All right? All right, let's talk about the Planning Commission. What is it? What does it do? Some of you have done this for a period of time. Maybe you're all still mystified. Just what is it that we're really supposed to do? The state code says you must have a planning commission. Every city and every county must have a planning commission. Now there's a caveat to that. The caveat is you don't need a planning commission if you're not going to regulate land use. What's the point? If you are going to regulate land use, you must have a planning commission. Because it follows, if the governing body has to get a recommendation from the planning commission, then you've got to have a planning commission. So just be aware of that. All of the particulars about that commission, the number of members that you have, what their terms are, can you have alternates, how do they get appointed, so on, that's all at the discretion of the governing body. They get to determine that usually by putting it in an ordinance so that it's clear what all of those rules are and that they follow those rules consistently. That's up to the governing body how to do that. But so they must have one if they're going to be involved in land use regulations. Now, what's the role of the planning commission? Under state code, this is what it is. They prepare and recommend a general plan and any amendments to that plan. Okay? Who prepares the plan? Not the staff. No, the planning commission and county governing body through budgeting, they hire the staff to help the planning commission prepare a plan. It's the planning commission's responsibility to prepare the plan. Okay? And then they recommend it on to the governing body. And then the governing body are the ones that decide whether they're going to adopt it or not, or modify it. It's the planning commission that has that responsibility. Same with the land use ordinances, zoning, subdivision ordinances, maps, zoning maps, official maps, and any amendments to any of that. The planning commission has the responsibility to prepare that and then recommend it on to the governing body. And then the planning commission can also act as an administrative body for people that want to do things under your ordinances and regulations, permits, land use applications, planning or conditional use permits, special exceptions, any variety of things that you may have in your code. You can have the planning commission act as the administrative body to do that. It does not have to be the planning commission. Under the LUDMA, the governing body has to appoint what's called the land use authority. The land use authority is the body that under your ordinances adopt or not regulates, does all of those approvals that are called for in your ordinance. Most jurisdictions, in fact, I can't think of any that haven't designated their planning commission as the land use authority. So that the planning commission will do that. Because you can do that, to kind of separate out that administrative authority, you can also give some of that authority to staff people to do that. And that's what some jurisdictions have been doing. More likely for staff, it's on the appeals process. We'll talk a little bit about that, and I think you've got a presentation coming from Craig Call that will talk more about appeal authorities and appeals, how that works under the land use codes, and what are some good ways to look at. So that's another responsibility the Planning Commission has, and it's really, we're going to talk about this, it's really important that you keep those two functions separate in your minds. The first function, which is to prepare and recommend the plans and the ordinances, and acting as an administrative body. Those are two separate functions, and they function in different ways. And if you don't understand how they function, you can get into trouble really quick. That's where a lot of the lawsuits come from, is because people don't understand what the difference in those functions is. And as I say, we'll talk about it. Well, we're going to talk about it right now. So, the first one I mentioned is what's called the legislative action. That's preparing and deciding on what your plan is going to be and what your land use ordinances are going to be. That's a legislative action. Okay, and the Planning Commission has a role in that because you prepare it and then recommend it on to the governing body. This relates to the adoption of policy and the rules to implement those policies. These kinds of decisions are more political than they are legal. You understand the difference? Political is what happened last night in Salt Lake City on the streetcar side. People coming in and expressing their opinion. Legal is once you've adopted your rules, do people follow, are they following the rules? Are they complying with the rules? So that's kind of the difference there. In the courts, when an issue is legislative, if somebody is appealing what's essentially a legislative action, the courts give a much greater deference to the local entity in those decisions, because unless they've done something that's clearly illegal, like they've been discriminatory on the basis of race or religion or something like that, or some other things that are clearly illegal or unconstitutional, the courts will give much broader deference. They'll say, if somebody says, I should be allowed to rezone my property because it makes more sense to me, and the city council didn't go along with that. Well, the courts, and then they take it to court, the courts will say, look, I'm not here to be a super decider. That's a decision that's up to the governing body in that community to decide whether that property ought to be zoned that way. They give them much greater deference in this area, and try not to insert themselves very much in what really should be a legislative process. Again, it's usually challengeable only in courts if there's clearly no public benefit, or if they try to do something that's clearly illegal. And these actions are what we call referable. What I mean to that is that isn't where somebody says to you, hey, have you done this before? Yeah, I got a great reference. I've been able to. No, that's not what that means. What referable means, it refers to referendums. And some of you are starting to get familiar with referendums, and I predict we're going to see more referendums. The Utah State Constitution gives to the people a power that the courts and the Constitution say is co-equal with that of the legislative body, and that is to make laws. The power to make laws resides in the state of Utah in the legislative bodies, the city councils, the county councils, the elected officials, the state legislature, and co-equal the people. And the way people do that is through what are called referenda initiatives. And there's some outline of what that is. And we'll talk a little bit more about that. We'll talk about it particularly tomorrow when we give you a little bit more of a legislative update what's going on with that. But legislative actions can be referred to the ballot. Okay, instead of taking these issues to court, which is what you do on the legal side of things, people can take these issues out to a vote. And they have the right to do that under the state constitution. And there's, of course, certain provisions that apply to that. We'll talk about those at some time, but that's the idea. Now, what are the kinds of things that are legislative actions? We've already talked about them. The adoption or amendment of the general plan, the adoption or the amendment of land use ordinances, zonings or rezonings, annexations. You as counties don't have to worry so much about that, but cities, when they annex territory, that's a legislative action. The adoption of fee schedules, things like that. These kinds of things are legislative actions, and they fall under those rules. Administrative actions. This is the other side of that coin. And let me just say right now, what I have advised a lot of groups, a lot of planning commissions and governing bodies to do so that they can keep the distinctions straighter in their head when they're dealing with these issues, divide your agenda up into legislative actions and administrative actions. It's a clue to you sitting on the body and to the public. The public generally doesn't know these distinctions very well. We're hoping, that they'll understand and start to learn a little bit more about them. But for you, it's a clue to say, all right, here on the agenda we have all these legislative actions that we're considering. Now we're on to administrative actions. I got to change my hat. I don't think this way. Now I start thinking this way. It's a tough thing to do for people. That's one thing I've discovered over the years. It's tough for people to make that switch. And it really helps if you give them some kind of a clue. And a good way to do that is to divide up your agenda between administrative and legislative actions. Administrative actions are things that are being considered under the rules and ordinances that you've already adopted. Okay? So you adopted an ordinance that says you can have conditional uses. And here are the requirements for conditional uses. Adopting that ordinance, developing that ordinance and adopting it is a legislative action. Now, you've got somebody that comes in, 7-Eleven comes in and they want to put a 7-Eleven on the corner, right? Under your ordinance, it's a conditional use. Now you're under administrative action. You already got the ordinances in place, now you're actually applying them. You're looking at an applicant that comes in, and a whole different set of rules apply to that. These decisions as you can guess from the other one, are more legal and technical than they are political. All right? You're looking at what it says in your ordinance, and you're looking at the applicant, and you're saying, do they meet the requirements of our ordinance? If they do, you need to approve them. If they don't, you can turn them down. All right? So what do when you have your meeting and you're considering that 711 under your rules for conditional uses, and people come up to speak to you and during the public hearing part of it, and they say, you know, I just don't like that. It just doesn't fit in our neighborhood. I don't think that's a good place for that 711. What do you do with that? What do you do with that? Can you say, you know, yeah, most of the people that are here tonight, they just don't really want to have it, so we're going to turn it down. Where they had the opportunity to say that was not a good idea was when you adopted the ordinance and the zoning in the first place. Now, once it's in place, you have to follow the rules that are in place. If you don't, you're liable to be sued by the applicant who was turned down because you didn't follow the rules. Okay, so, as I say, those decisions are more legal and technical than they are political. When these type of things go to the courts, it's a much more strict standard of review courts use. They don't give a lot of deference here. They say, what does your ordinance say? What did you do? Did you follow your ordinance? If you didn't, then you may be liable. All right? Yeah.
So, using that same scenario you were just using, to what extent can the planning commission place conditions on the applicant?
Okay. The question is, and I'm doing this for the video, folks. Most of you probably heard, but for the video, the question is, what do you do can the planning commission essentially make up conditions? You know, that used to happen a lot, and ordinances were drafted pretty broadly years ago to say, you know, and I saw a lot of zoning ordinances that actually had a phrase in them that said, so for a conditional use, it has to meet this, it has to be traffic, odor, light, various things, and maybe had standards with them. And then there was oftentimes a catch-all at the bottom that says, whatever other condition that the administrative body decides to impose. Those are all gone now because that was getting us all into trouble. Because basically what you had was people dreaming up ways of trying to either approve or deny something. And there wasn't any real basis in the ordinance for it. And so the state legislature several years ago modified the code to basically say that conditional uses are to be considered essentially like permitted uses as long as they can be reasonably accommodated. That's not the right word, for some reason the right word is mitigated. That's it, thank you. They can be reasonably mitigated. And so now what all of the legal folks are saying is that put your standards in your code, in your ordinance, so it's clear, and then you got to stick with those standards. And you can't really be making anything up. Be pretty straightforward and clear about what the standards are in order for a use to be there. The idea is if you don't want to use, and what we as planners tell people now is if you don't want that, if you don't think that use is a good idea in that zone, then don't put it in the zone. If you're putting it in the zone as a conditional use because you're thinking, well, maybe it'll work, you know, but if you just don't think it's a good idea, don't put it in the zone. Because if you put it in there, even as a conditional use, the state code now says that's presumed to be allowable in that zone. And you may just have to put a few conditions on there to mitigate a few impacts that they may have.
Perhaps you could explain types of conditions that can be applicable. And what I mean by that is some zoning codes say these are the types of things that the Planning Commission and County Council may look at when considering this type of use. And that gives the County Council and the Planning Commission some deference in choosing which ones of those things they are going to apply.
Yeah.
But to keep us from making things up as conditions, what relationship does the condition have to what's written in text?
What you really need to do, I think, is you really need to identify what are potential negative impacts from a particular use and then put some standards in there. So if you say, for example, let's stay with the 7-Eleven example. You say, okay, the 7-Eleven is conditional. Because, why? Why would you make it conditional? Because it may have traffic impact, it may have light impact on the surrounding neighborhood, and it may have some kind of noise impact. So put some standards in there with regard to those. Say, the traffic has to be accommodated on a major street and not encourage that traffic to go on the residential street. The lighting standard, all lighting has to be facing down and not glaring, and maybe even put a specific brightness to it. Noise standards, the same kind of things. So put some standards in there. Try to think through what are the potential impacts that you would have to mitigate in order to allow for it to be in that zone, and then write some standards.
So I guess the reason for the question is, with those standards in the ordinance, why address things on a conditional use basis?
Yeah, and that's a really good point. Generally, when you have a permitted use, the idea is that it can go in there. They don't have to come get anybody's permission. They can go in. They just have to go get a building permit or whatever is required, then they have to meet the building code stuff. But anything else, there's nothing else that needs to be looked at. With a conditional use, you're saying, yeah, we think it can work in the neighborhood as long as they don't exceed these impacts. And so that's where you're coming up with these standards to say, you can have a 7-Eleven in there as long as you do these things. But if you can't do these things, then we won't allow you to go in there. And if you've got those standards clearly articulated in your ordinances and they're reasonable, you're probably okay. As long as you stick with them. Okay? You need to stick with them. What are the standards that you have?
Well,
Yeah.
if they're so administrative, why have the planning commission do it? Why not have staff do it?
You can. You can have staff do it. Elected officials like to retain control. They feel like that's what they're elected for. So sometimes there are jurisdictions around that require the conditional use permit to be approved by the elected officials. Oftentimes with a recommendation from the planning commission. Or they give that authority to the planning commission because at least they feel like those are citizens that they've appointed. So that's oftentimes why that happens that way. It's a political reason. But there's no reason why it can't be written in your ordinance so that staff could do that. The same type of things applies to appeals. Craig Call is sitting in the back. He's going to talk to you about appeals and how that works as well. How you can do that, and kind of down to the staffing. Under administrative action, I put on here the term no public clamor. Well, you're going to get public clamor anyway, but it can't be the basis for your decision. There's a court case out there, and there are people around that claim distinction for things that they've accomplished in their career. Like I was a planner that was in on creating the land use management approach to planning and so on, various reasons. My claim to fame is I was the planner in the court case that said no public clamor, which was in Clearfield City. And so the courts have said you can't base a decision, an administrative decision, on what they call public clamor. The public shows up, they say they don't like it, they don't want it, and it gets turned down on that basis. You have to have evidence based on the standards that are in your ordinance in order to consider what you're going to do. So be aware of that. That's a big difference. And these decisions are not referable. Okay? These things cannot be taken to a referendum vote. They can, however, be challenged in court. So there's a distinction there. Yeah.
So if public clamor, so it'll be on the other end of whether or not to change the zoning. But once you change the zoning, then it's over.
Yeah, though this zoning is an interesting thing because our appeals courts and the Supreme Court have not definitively said whether a rezone is administrative or legislative. Generally, it's considered to be legislative, but there seem to be instances in which the sentiment is that they're administrative. So, how to give you guidance on that? I don't know. I'm going to let Craig do that one of these days. Tell you what's the difference between administrative and legislative rezones. It isn't really clearly distinguished. If it's generally, the general rule is if it's a rezone for a big area, a lot of properties, that's considered legislative. If it's a rezone of a single property, that might well be administrative, given what your plan says and how it works and various things like that. So we still need to get some clearance or clarification from the courts. All right, what kinds of things are administrative actions? Well, the issuance of permits, that's an administrative action. Site plan reviews, conditional use permits, subdivision reviews, just the approval of any land use application, an application that comes in to get something that is allowed under your ordinance, or that is dealt with under the ordinances that you have in place. Those are administrative kinds of actions and fall under those rules. All right, I put this in there because every planner should, yeah, questions? It will be. I'm going to send it to Sonia, or Sonia, anyway, so yeah, and you can get it from her or from UCIP here. They'll have it. Every planner, I'll show you the classic planning process, right? So that's what this is. This is the wheel that you go around. You know, you identify issues, you research the options, you evaluate the options, you adopt the preferred option, you implement it, you evaluate it, and you start over. The classic planning process. This is really what more looks like, you know, the real planning process. And it's just the nature of the beast. It's just how things work out there in the real world. So with regard to the plan or the planning, again, in the state code, it says that each municipality and each county now as well shall prepare and adopt a comprehensive long-range general plan. The key word there is shall. It says you shall do that. Wow. You know, a lot of people didn't realize that you're required under the state code to do that. What if you don't? There's no penalty. So, you know, don't know that it's really has all that much force, but it is required. And as we talked about, what's the general plan? As we mentioned early on, it's that policy guide for the development of your community. It's a statement of your vision and goals and what you want the community to be, basically. That's what you're articulating in your general plan. So what's in the plan? Well, under the state code, the general plan, you're required to have three elements: a land use element, a transportation element, and a moderate income housing element. All right? So you're required to have a land use plan or a general plan, and the plan is required to have those three things addressed. All the other things that are often in plans, about the environment, about public services and facilities, rehab and redevelopment, economic development, and how you implement the plan, all of that other stuff is optional. It can be in the plan, but it's not required to be in the plan. Most plans do have a variety of other elements in it along these lines. But those three over there on the left are required to be in the general plan. Again, as we talked about, who prepares the plan? It's the planning commission's responsibility to prepare the general plan. Now you say, well, we don't really do it. You know, the staff we hired, our planner does it. Yeah, that's right. The county commission, or the county council allocated money to hire a planner to help you, the planning commission, do this. Or they may allocate some money to let you hire a consultant to help you do this. But they're not on the hook for it, the planning commission is. It's the planning commission's responsibility. Now, how do you do planning? This is up here, is how do you do planning? Do it in a vacuum? No, of course, it's much better to do it with broad public involvement. And this is just the pitch to involve the community. It's their community, you're there representing them. But, you know, get their input, get their feedback. In today's world, with all of the various ways we have of gaining input from the public, it's criminal not to do it. You're not required to. Actually, you are required to do one thing, or a couple things. First of all, if you're going to do a general plan, you have to do it in intent notification that you have to give to these various entities 10 days before you start your process. Well, you know, a lot of times when you're going to do a general plan or an update to a general plan, you say, well, I think we're going to do this. And how do you know when you're 10 days in advance? Well, if you're thinking about it, it looks like you're going to do something with your general plan, send out a little notice to these entities. An affected entity is generally defined as, if you're a county, for example, probably all of the cities in your county and special service districts in your county. You know, notify all of them. The state EGRC, the AOG in your area, and then you put the notice also on the Utah Public Notice website. The idea is to let them know you're going to do something that may change what they have to do in the services that they provide. That was put into the state code a few years ago. So you got to do that. You got to give that notice. The other thing that you have to do is you have to have a public hearing before you can take any action on a plan. So that at least is the role of public involvement that's required in the state code. Don't just do that and call it good. do the bigger, broader thing, you know, have community workshops and allow people to comment on your website and send emails and do a lot of stuff like that. All you're required under state code though is you have to have a public hearing. And the public hearing has to be before the planning commission. Okay, so the planning commission has to have that public hearing before you can make a final recommendation on the plan. Even if you do all of those other forms of public input and still, you know, have that formal public notice with all the notifications that are required in the state code and everything else before you send on that recommendation. Now, the actual adoption of the plan is done by the legislative body. City council, the county council, the county commission. When that body gets it, a lot of people say, well, they have to have a public hearing too. They do not. I don't know too many legislative bodies that wouldn't want to have a public hearing, but they're not required to under state code, okay? Just kind of an interesting fact to keep in mind. When the legislative body gets it, they can review it and they can make revisions if they want to, okay? They can make changes, and then they can either adopt it or reject it. That's their option. Now, I know a lot of people that are on planning commissions, they sometimes get upset when the governing body doesn't take their recommendation and just adopt it. They're like, well, what are we even here for? Well, you really need to understand your role is to recommend it. And the governing body still has that legal authority, has the responsibility to adopt it, and they can make modifications and then adopt it. Or they can outright reject it. That's their option. But you as a planning commission, you know, kind of the idea is, the whole idea of planning commissions came about back in the early 1900s because of the perception of government as being corrupt. Right? It's not corrupt nowadays, but the idea of it being corrupt, that it was beholden to special interests, that the elected officials got in there by dint of being subject to somebody else, and you know, they were just generally local government. You know, you think about all of the big political machines that existed in the big cities in New York and Chicago and so on, and that was the perception of government, certainly of local government. And so when this whole idea of doing planning came about, it came up with this concept of a planning commission. Citizens that were appointed by the elected officials, but at least by being citizens that were appointed, they were maybe a little bit more removed from that corruption and biased picture that the elected officials were considered to have. And so that's where the whole idea comes from, is you're closer to the citizens, you're part of the citizens, you make the plan, you recommend it on to the governing body. And if you've done your job well and you've gotten lots of public support, the elected officials generally will go along with it because they don't want to be perceived as, you know, if they don't accept your recommendations, then the questions maybe begin to come as to, well, why aren't you accepting the recommendation? You have somebody else out there you're beholden to, you know, and that you're trying to change something in favor of somebody. So that's kind of where the idea of the concept comes from. But still, they have the ultimate responsibility.
Yeah,
Yes?
but the legislative body can't amend it?
Yes, they can. They can amend it.
Okay.
They can change it and then adopt it, revise it. Yep, they have that authority. Well, once you've adopted a general plan, what does it mean? In municipalities, the state code says the general plan is an advisory guide for land use decisions. So you have a plan, your plan says that we should have these kinds of land uses in these areas. You put in place zoning for those kinds of uses. Do you have to follow your plan? Under the state code, you do not. The governing body can make a decision that does not follow the plan because, at least for cities, it's an advisory guide only. There's no force of legal action that can be taken for just saying that you're not complying with your plan. Okay? It's advisory only. In counties, interestingly enough, it's a little different. Again, it also has that language about being advisory, but then it also says that the legislative body may adopt an ordinance mandating compliance with the general plan. So counties can make compliance with your general plan mandatory. Cities can't do that, interestingly enough. I can tell you the legislative history of that. It's kind of interesting. And we'll do that one of these days. Maybe when we talk legislative tomorrow. But anyways, just be aware of that language. I think a few counties have done that. I don't think a lot of them have, but they have the ability. All right, once you have the plan in place, it also means that for you as a county now, you cannot put any street, park, other public way, ground, place, space, publicly owned building or structure. Did you know that? Any publicly owned building or structure, any public utility, whether publicly or privately owned, can be constructed or authorized unless it complies with the general plan. Okay? So your plan has, whatever you're going to do as a governmental entity, you're going to put a library over here, you're going to put this kind of facility there, you're going to build a street here. It has to be in compliance with your plan. It's required under state code. So make sure as you're addressing your plan and getting ready to do that, that you address these issues in your general plan. You can be fairly general. You don't have to say specifically this is where a library is going to go. But what you can say is in this area, we can put public facilities or something like that. You can be fairly general, but at least you have to show that you are in compliance with that general plan before doing those things. Yeah.
If the zoning permits these types of uses, for example, a library,
Yeah.
the county still has to follow, but the general plan represents something else for that.
Yeah. Yeah, right. You need to be in compliance with that plan. Now, once you've adopted your plan, how do you implement it? You implement it in a variety of ways through land use ordinances, through budgeting, development regulations, other government actions, and of course, private investment and development. Because your ordinances and codes are now going to guide where that private investment and development goes. And hopefully, develop the kind of community that you wanted as you reflected in your plan. So let's talk a little bit now about those land use regulations, which are the implementation. The main one that most everybody uses is the zoning ordinance. It regulates the use of land. Under a zoning ordinance, you must allow some viable use of land. You can't zone a property and not allow any kind of use. If you've done that, you've essentially affected what's called taking of value, of all value of that land, and you can be liable to paying for that as a taking of private property. So just be aware that your zoning must allow for some kind of viable use. There's a lot of debate over what is a viable use, and how far can you go, and how much value can you take before it's total taking. Does it have to be total taking? There's a lot of legal questions around that, but essentially just be aware that you need to allow some kind of viable use. Usually zoning ordinances include a zoning map. And of course the trend today is more towards mixed uses rather than saying commercial here, residential here, industrial here, public uses there, or open space and parks here, something like that. The trend today is much more towards mixing those uses in some limited way, recognizing that communities maybe are a little more viable and work with that doing. So in your ordinance, you generally have what are called permitted uses. These are, as we already talked a little bit, these are the uses that you allow by right. That is, every property in that zone has the right to have any of these uses on it without getting any further approval from the government. Okay? In a residential zone, it generally means, you can have a house, you can have a garage, an accessory structure, a variety of different things. You define that in your zone. The commercial zones maybe get a little more detailed in the kinds of things, and then of course if you're doing kind of mixed use zone, it's going to be maybe more detailed with regard to that. But those, once they set the basics, they meet the basics like the setback and the height and so on. If they show that they meet all of those requirements, you just give them a permit and they go ahead and they build. They generally don't need any further review. It's usually a pretty simple approval process. You just kind of look it over, the plan, say, oh, let's see your plan. Yeah, you meet this, this is great. Go ahead. You're done. Go for it. Then you have what are conditional uses. We've already talked, I think, in pretty good detail about that, as to what a conditional use is and why you would have it in your ordinance. It's something you think maybe will work in a given zone in an area, but it may have some impacts that you feel like need to be mitigated or modified in order to allow them to be there in that location. When you adopt a zoning ordinance, you also, almost by default, create what are called non-conforming uses. That is, that things have gone on. Our cities and towns were around before there were ever zoning ordinances, right? And I can tell you that from, I told you about the fire hose analogy with Salt Lake City. that's a lot of the fire hoses that, you know, a lot of things happened in Salt Lake before there was ever any zoning. Or zoning has changed over the years. And at one time you allowed certain things, but now you don't anymore. So you create what are called non-conforming uses. Those are uses that existed at one time legally. But now, because of the ordinance that you adopted, they're no longer permitted. They have the right to continue to exist, but there are certain rules that apply to them. And so that's what we mean by non-conforming. Something that existed legally at one time, but now it no longer would comply with the ordinance that you have in place. A lot of people get this confused with people who, property owners who sometimes do something that was never legal in the first place, right? Under maybe ordinances that you had in place at the time. And like, for example, say you have a zone that allows only single-family homes, and somebody put a basement apartment in, right? And essentially made it a two-family structure. Well, you had a zone for two-family structures, but this wasn't the area for it. Well, if it was never legal in the first place, it ain't legal now. They don't have a legal right to exist. But that, and this is, you know, in some places like Salt Lake City where it's been going on for so long, how do you know, and property owners have changed so many times, how do you know if that basement apartment was ever legal? When was it first established? Was it established before there was ever any zoning to begin with? Well, I don't know. Let's go ask the neighbors. Well, none of the neighbors were there either. It really gets complicated sometimes. But that's an issue, and then there are a certain set of rules that apply to non-conforming uses in the state code in order to allow them to continue. So just be aware of those, and you usually have a section of your code that relates to those.
Okay, well,
Yeah.
we'll move on from that. Who has the responsibility for bearing the burden of proof?
With regard to non-conforming uses, you can do it a variety of ways, but a lot of times you do this by, a lot of jurisdictions send those to their appeal authority or to their board of adjustment to determine compliance or allowance with non-conforming uses. But it really isn't specified. You can do it really just about any way you want, where you have that kind of authority to make some determinations. This one's a little trickier. This is variances. Now, when you adopt a zoning ordinance or a land use code, you're not going to be able to cover every single circumstance that may exist, right? So, for example, you adopt a residential zone, you say you can have a single-family home. That single-family home has to have a 10-foot front yard setback, a minimum of 25 rear yard setback, and 5-foot side yards. Okay, just for example, if you say those things. Okay, so you apply that to an area. Well, guess what? Here's somebody that owns a piece of property that's probably big enough, but they've got this big ravine, gully that runs right now through the back of their property. And if you make them have a 10-foot front yard setback, they're going to put that house right in the ravine. Now that's not necessarily fair, is it? Because then what you tell, you're essentially telling somebody, well, everybody else can have a single-family home, but you can't. And so then what does that person do with their property? Well, this may be a situation where you look at and you allow for whatever variances to your ordinance. You have general rules that apply, but there may be some circumstances, some properties and property owners that can't meet those requirements, and therefore they may not be able to do what everybody else in the zone can do. So you give them a relief valve, a safety valve, which is a variance, and saying, all right, the circumstances, the rules that you apply in looking at whether someone can be allowed a variance are actually in the state code. So it tells you what the rules are that you have to apply to someone who's looking for a variance. You know, is it this, is it that, is it that? Hardship, you know, is it self-imposed, self-created? There's some other standards in there. You look at that, and if they comply with all of those requirements in the state code, then you can grant them a variance from your standard rules. All right, in your case, we're going to allow you to have a 5-foot front yard setback, because if we make you have a 10, you're going to be in the ravine. Okay, so those are the kinds of things you can do, and you put those provisions in your code to allow for variances. This is one of the most misunderstood areas that people deal with, and it's one of the reasons why Craig's going to talk to you later about why you might be ought to consider going to an appeals officer rather than to a board of adjustment. These kinds of things are generally decided by boards of adjustment. That was the model code, and that's how it's set up. Under our LUDMA now, you have the option of designating who that appeal authority is going to be, and it can be an individual, and Craig's going to talk to you about that, but generally, my experience with Board of Adjustments is that they don't understand the rules generally that apply to this, and even when they do, sometimes personalities get in the way. Fred's been a good guy in our community forever, we're not let him do it, you know, he's an old guy. But here comes, you know, XYZ Corporation, oh, it's doing good, we're not giving them variance. It happens. And so there are better ways to deal with it. You'll hear a little bit more about that later. Another type of land use regulation that's generally employed in most communities are subdivision regulations. This governs the division of land for present or future development. Why do we have subdivision regulations? Why do we control whether people can divide their land or not? Well, a lot of this comes from sad experience, where over the years people have divided up property and sold it to other people, you know, by misrepresenting or not representing at all. People thought they had certain levels of service, they had water and sewer and everything else that was going to the property, and they didn't, or it wasn't adequate. And so over the years, it's kind of developed so that we have subdivision regulations which say before you divide up that property, you have to, and you want to sell it. The purpose that you're dividing for is to sell it to other people to allow them to build on it and develop it. There's a certain level of service that has to be assured. Water lines, sewer lines, sidewalks, streets, all the things that go with that. And that's kind of the main purpose behind having subdivision regulations. Under the state code, a subdivision means any division of land. Okay? That's what it says in the state code. It's any division of land. All right? But it says there are some things that are exempted from locally adopted subdivision regulations. Land that's used exclusively for agriculture, they are exempt from subdivision regulations. The adjustment of lot lines between owners. So, you know, one owner says, hey, you know, I have a little RV pad over here, can we move the property line between us? Yeah, fine. That's exempt from subdivision regulations, as long as they don't make their properties non-conforming. And put that rule in there. And joining the properties together. You know, two properties, erase the property line between them, put them together, that's also exempt from subdivision regulations. Under state code, a plat is required for any division of land, except for those exceptions I just told you about. It's required for any division of land. You, as a county, have the option of exempting, in addition to those allowed in the state code, exemption for divisions of land of less than 10 lots. You can do that. You don't have to do that, but you can do that. You can say that a division of property into less than 10 lots, we're not going to regulate. Okay? It's an option that you have. It still requires, though, even if you exempt that there has to be a record of survey map that's prepared and filed with the county surveyor. So they still have to do some kind of map showing it. And it has to be one that doesn't require a dedication of land for public use. So let's say somebody says, I'm going to divide my farm field into 5 lots. Great. Go ahead and do it. Just have to do the survey record map. But do they need to provide, you know, to get to some of those lots, they got to put a street in there. Well, if they got to dedicate land for a public purpose like a street, then you got to do subdivision. Okay? That's just no choice. You got to do subdivision. And meet those requirements. And again, as we talked about, there's an exemption there for agricultural land. And there were some things that were done in this last legislative session with regard to this as well. We'll talk about that tomorrow. Again, subdivision regulations are intended to make sure that minimum lot areas under your zoning are met. Right? Your zoning says that in order to have a single-family home on this property, you got to have at least 10,000 square feet. Well, okay, so how do you make sure that happens? Well, with your subdivision regulations, you can't create a lot unless you say it's okay, and you're not going to okay the lot if it doesn't at least meet the 10,000 square foot rule. And all the other requirements that you may have in your zone. And it also makes sure that those necessary improvements are in place. Mike?
Is any progress? I mean, one of the challenges we still have in this area is if someone brings a valid document to a county recorder, they're obligated to record it and just do it, regardless of what our ordinances say and what the state code says.
Yep. And the county recorder still maintain that and do that.
So we're
We're just stuck with the illegal lots or subdivisions then.
Right. That's what happens.
You know, and in rural counties, it still happens
Oh, yeah.
every day,
It happens everywhere.
every day.
Yep. The issue is really, I mean, people have a right to divide their property, they can do that. They don't necessarily have a right on what happens on that property. It has to comply with the local regulations. I mean, the idea there again is, you know, I mean, I had this happen when I was in Davis County. We had this young couple come in, just, you know, been married not too long. They come in, we'd like to get a building permit. Okay, let's see where your property is. Well, they bought this piece of property from some guy out in a farm field, you know, with not a lot of improvements around the area. We're like, sorry, you can't build on that property unless you do this and this and this and this and this. And they're like, well, we can't afford that. But the guy told us we could build on it. He went to the county recorder's office and divided off and sold them the property, right? They're stuck. We're looking at this young married couple, we just put all the money they had into this property, and they're like, what do we do now? And we're like, go back and get your money back. The guy's not here anymore, he left the state. It really makes it hard, you know. Again, I mean, you know, the adage is, you know, buyer beware, but this, you know, this sort of an attempt to try and at least get some assurance that there's some potential for development when people have sold property on that basis. Yeah.
Well, you know, and that's the key thing with the buyer beware. It really brings in to point with the due diligence when people are buying property. They need to come in, they need to check zoning, they need to make sure it is a buildable lot. You know, it's not just what's the zoning, what's your frontage. They need to verify that it has gone through the proper subdivision process to make sure that they can build on it. You know, they just say, what's the frontage, what's the setbacks, what's, you know, you need to make sure it has gone through the proper subdivision process.
Yeah.
Because, you know, we've had cases like this in Morgan where people have subdivided a remnant lot and the people have actually had to go through the subdivision process to make it, because
Yeah.
they were sold a quote unquote buildable lot.
Yep.
And had to go through a 2-year process just to put the home on it.
Yep.
And so, you know, it comes down to, unfortunately, the buyer and the seller making sure that they are buying what they really want to buy. It comes down to that due diligence.
Yep. So this is kind of a partial way to try and deal with that, but it's by no means, you know, absolutely guarantees anything in that regard. So it's something to be aware of. Okay, another thing that happens a lot with our land use regulations and what we do is, especially when development is involved, we have impact fees and exactions. This is in order to get necessary improvements in order for, you know, urban development to take place. You need to have roads and streets, you need to have places to put your water lines, sewer lines, power lines, and various other things. And so what it means sometimes is that, like, if development's going to happen in a given location, well, we've got to widen the street, or we've got to put one in the first place. And so often a local jurisdiction can do what they call an exaction, which is to say, you know, you're going to put this kind of development in there, you and then subsequent development, we got to widen the street. So in order for us to approve your development, you need to give us some property so we can widen the street. That's an exaction. Another way this is handled is through what's called impact fees. That is, the local government says, you know, we're going to have all this development, we've got to build these roads, we've got to put in this water system, these water lines, we've got to put in these sewer lines and sewer system, and this is going to cost X number of dollars. When that new development comes in, they need to pay their fair share of that. And so then you know, there's a whole series of calculations on how you do this process in the state code. And so the local jurisdiction follows this, they come up with a dollar figure and they say, all right, if you want to do 10 lot subdivisions, then you need to pay us X number of dollars so that we can develop the water system and the sewer system and put in the roads and do it. And those are impact fees. Generally, I think these days what happens is now, you know, you kind of come up with that cost and either do it as an impact fee or if you're going to do an exaction, require them to give you some property in order to either widen that road or put in that water line, then you kind of take that off of what they owe you for impact fees. It's not you do both, you kind of, you know, it's got to work together so that you have an equitable way that you're treating all the properties fairly, okay? Now one thing, when you look at the various kinds of services that you can do this for, you can do it, as I mentioned, for sewer lines, water lines, parks, major roads. You can even do it for fire protection, but you cannot do it for schools. Schools under the state code are not allowed to charge impact fees. that was a political decision several years ago in the state legislature, as the schools were looking at ways to be able to provide facilities that the growing population needed, but it was a political enough issue, and it was put into the state code that schools cannot be charging you taxes. Okay? It's something to be aware of. So we'll spend a lot of time on this. We're going to get into that time. This is what they are. We just talked about that a little bit. Again, you need to have a balance between the two, and you have to have a sound basis for them. In other words, you got to have a pretty good idea. If you're going to allow development in an area, you've got to have a pretty good idea of what it's going to take in the way of services to allow for that development. And you put that into what's called the capital improvements plan, and then you use that as the basis to make your cost estimates and your calculations. And there's a lot of rules now in the state code that apply to that. It's gotten to the point where, I don't know that really any local government can do that on their own. They really need professional help in order to do it. And the development community will make sure that you do, because they don't want to be paying for something that they don't think is necessarily right or fair. So it's a hot area, but it's something you need to be aware of. There's the issue of vested rights. What is a vested right? That's essentially your land use codes and ordinances as they exist. If someone meets your requirements, then they can go ahead and develop, even if you change the rules. Now, this is not the same in every state around the country. It varies from state to state. States have different rules as to when a development proposal becomes vested and has the right to proceed. Any of you remember, this is years ago now, but the case where there was a building, I think it was back in New York, where they had actually built the building and they had put, they topped it out. They had built this building that was several stories high, and the jurisdiction changed their rules and they had to go back and actually take some floors off of the building. All right, so that can happen. That's what you call a very liberal vested rights rule. Utah has probably one of the most conservative vested rights rules in the country, and of course I think many people feel like it's the right way to go. So here's how a vested right works in the state of Utah. With the ordinances and rules that you have in place at a given time, if an applicant comes in with a land use application to proceed under your rules and ordinances, and they submit to you what's called a complete application, that is, they have all the information in there that you require. On the day they have that complete application, they give you an application and you say, this is complete, we've got all the information we need, they're vested on that date. Whatever rules you have in place on that date, they get to work under, even if you change your rules later. Okay? So you may be saying, well, we're probably going to look at changing our zoning here and not allow for this kind of development. Well, if they get in there and get you the plans, it's a complete application, boom, they're vested and they can move forward with those plans, even if you wind up changing the rules later.
Two questions on that. One, in our code, there's a expiration clause, so an applicant.
Oh, for an application, sure.
Will expire after
Yep.
so many months.
Yep.
If their application expires, it will no longer be vested.
Right.
And the second, let's say subdivision, you have concept, preliminary, or final, or just preliminary, final. There's several stages.
Yeah, please. Right.
If they get vested at concept, but
And they don't pursue it?
well, even if they do pursue it, but meanwhile, the code changes
Oh, yeah.
for preliminary and final,
Yeah, no,
are they vested for the entire process?
you should talk to your legal counsel, but I would say generally, yeah.
Okay.
Once they've applied for a subdivision, you have stages of subdivision requirements, approvals. But once they've actually applied for that subdivision and they've got a complete application into you, they're vested. Okay. Now, there are a couple of exceptions to this. The exceptions are, if your governing body has formally expressed an intent to change the rules. Okay? So what you do is you basically go to your governing body and say, we want to change the zoning in this area so that we no longer allow for 7-Elevens. Say, we're going to change the zone and change it out. And maybe you do that because you know somebody's thinking about putting a 7-Eleven in there. And that ain't going to go over very well on the neighborhood. So what you really need to do is you need to go to your governing body, your county council, county commission, and and say to them, would you please adopt or at least express in the public meeting that you are formally looking at changing the ordinance to do this? And then that starts a clock. And the clock is generally about 6 months long. But what you said is you put everybody on notice, we may change the rules to do this. And once you've given that notice, then anybody who comes in with an application, you can say to them, you know, not that you can't move forward, but what you basically say is you can go ahead and apply and move through the process, but if the rules change in the middle of this, you're going to have to change your application or withdraw it because it's no longer allowed. You can do that as long as you've done this, formally express the intent to change the rules. Now, that's not something you can just say or have your governing body say, and it carries on forever. It only lasts for about 6 months. So you got to make your rule change in that time period. Otherwise, you're back to the rule that you had in place, and they move forward with their application. Question?
We recently had this happen in our county where, regarding our affordable housing, and I had always thought that it was sufficient to just have our council say, you know, address it in a public hearing, and our legal council said, no, we want an ordinance signed saying we are reviewing it.
Yeah, for the sake of those who can't hear this, the question was, some folks thought it was sufficient to just go to the governing body and have them say in a meeting that they wanted to look at this, but that may not be adequate. In Salt Lake City, what we do is we actually have a written petition that we have the governing body, or in our case, because we're a mayor, council form of government, that the mayor adopts, signs off on. So we actually have a written petition saying we want to change this ordinance, or we're going to look at changing this ordinance. So you need some kind of a formal declaration, really, we say.
And does that go on as an agenda item in the meeting, and that's the...
Yeah, probably.
That's essentially your declaration that we're looking to change.
Probably would be a good idea to do that. Yeah.
Would the written minutes be sufficient for that?
The written minutes, I don't know. Craig, what would you say? Are written minutes sufficient to say that you've declared your intent to change an ordinance?
An agenda is a whole lot better.
Okay. So you have an agenda, then you actually haven't taken action.
Right.
Yeah,
I think
I would agree. I would.
what the rule says is you need to be considering a change in the ordinance. So you ought to have a draft of a change in the ordinance. The rule is called the pending ordinance. So
Right.
it's more than a glimmer in your eye.
Right.
But to really be, we had an issue in the town where I'm city attorney about adult businesses. We were worried that they were on the verge of coming up to the door, and it isn't that we could prohibit them, we just wanted to make them a conditional use. So we simply attached a copy of Provo's ordinance to an agenda item and said, here's an example of what we might consider. We're absolutely perfectly protected.
Yep. So, just be aware that is the one of the exceptions to the vested rights rule as it exists. That you can do this declaration, formal declaration that you're thinking about changing your ordinance, or you may want to change it in this way. The other exception is if there's a situation of what's called a compelling, countervailing public interest. Now that is not an easy thing to match or to meet. It really is, it's pretty serious. The example that I like to use is you approve the subdivision, people are starting to build homes, things are going along pretty good, and this hillside starts coming down in part of the subdivision. You know, the land's moving, and it's coming down, and I mean, who knows what's going to happen. And somebody shows up at the counter, this makes no sense whatsoever, but I swear to you, this has happened. Somebody shows up at the permit counter and says, I want a building permit to build a house on that lot, where the land's sliding. Right? You say, first of all, you say, what kind of an idiot are you? But, you know, they're certainly well within their rights to ask for it. You can now say, there's a compelling public interest, because anybody who lives in that house may be seriously hurt or killed when that landslide completely goes. So you can stop them from exercising their right to move forward with an application on that kind of a basis. But it has to be something that serious. It's not just because you say, you know, well, the public feels like that we want to change uses, and so we're going to stop you from applying. You know, no, it's got to be much more serious than that. Kind of at that level. I'm not gonna talk a lot about appeals, Craig's gonna talk to you more about appeals, but in all ordinances, all land use ordinances, you have to provide for an appeals process, so that people who feel like that you made the wrong decision, or they don't agree with your decision, have a way to appeal that. Generally, the step is you first, again, as I mentioned under land use, the LUDMA, you're supposed to designate a land use authority, but your governing body is also supposed to designate an appeal authority. And that's to handle this appeals process when people don't agree with your decisions. Generally, the appeals bodies in most jurisdictions are the Board of Adjustment. That's, the Board of Adjustment was created as part of that model code back in the 1920s. But more and more jurisdictions now are going towards what's called an appeals hearing officer. It really works a lot better. We're doing it in Salt Lake City. A number of other jurisdictions are doing it now, and Craig's going to talk to you more about that. And in the interest of full disclosure, Craig is our appeals hearing officer. And he does a great job. And there's a lot of good reasons for that. So just be aware you need to do that. And again, this is administrative, so this applies only to administrative decisions, not those legislative decisions that I talked to you about. If somebody wants to appeal a legislative decision, which ultimately has to be decided by the governing body, there are two ways they can do it. They can file in court, but it's going to be tough in court because, as I mentioned, the courts give a lot of deference to local jurisdictions on those legislative decisions. The other way they can appeal a legislative decision is take it out for a referendum, for a vote of the public. And so that's how you do legislative ones. This type of appeals is for administrative action. As I mentioned, you have that referendum process. Gee, I forgot I had that slide. I shouldn't have talked about it beforehand. But for a variety of reasons, I think we're going to start seeing more referenda with regard to land use decisions. We'll talk a little bit more about this tomorrow when I do the legislative update. But it is a process that's gaining some notoriety, has been successfully used in some jurisdictions as of late. It's complicated, and there's a lot of issues, and there's been a lot of court cases around it, but I think we're going to see more of it, particularly given what's been happening in the last year or two about those kinds of decisions. So that's it. That's Land Use 101. You got the basics. You remember it all, right? We're going to give you tests. Yeah.
The one thing you didn't mention that I think people ought to know rurally, the federal government will give preference to the general plan.
Okay.
So they actually, even though if they have their resource management plan,
Yep.
we're going to do this, this, and this. If the county has a general plan,
Yep.
the county's plan will supersede.
I don't know if it'll supersede it, but I think they have to pay attention. They have to pay some attention to that local plan. It won't necessarily supersede, I don't think. Right? It has, really? Wow, that's pretty good. If you've been able to do that. But I do know, I mean, at least I know at least that the federal agencies are required to pay some attention to that one. So that's one of the reasons several years ago I was involved in an effort when I was in Davis County, and this was being done through UAC, was to get every county in the state to have a general plan. For that, partly for that reason, to be able to deal more effectively with federal agencies. So something to be aware of. So, any other questions, comments? I'll be back tomorrow and we'll talk legislative update, and that's the fun stuff. Thanks.